So we're going to start off with giving a quick overview on the different protected leaves, and that first one is the Family and Medical Leave Act, or the FMLA. This is the federal law, and it applies to employers with 50 or more employees at a work site within a 75-mile radius. As you'll see, you may fall under both FMLA and CFRA or one. Um, and we will be talking about how they can run concurrently and what the differences are between FMLA and CFRA. But it is important to know who is eligible and what types of leaves our employees are entitled to under both FMLA and CFRA. So who is eligible under FMLA? An employee who has been employed for a total of at least 12 months prior to the commencement of the leave. And it's important to note that this 12-month doesn't have to be a consecutive 12 months. They just have to have been employed for 12 months prior to the commencement of the leave. However, they also have to have worked 1,250 hours in the previous 12-month period. So that is something that sometimes an employee may be right on the cusp of that, and it's something that you may need to check with your timekeeping system. And an employee would be entitled up to 12 weeks of leave in a 12-month period. These are the different qualifying reasons for leave under FMLA. The most common ones are the employee's own serious health condition, and then caring for a family member. Now, the FMLA does define the family member as a parent, child, or spouse with a serious health condition, and it also includes bonding with a newborn and adopted child or a child placed in foster care with the employee. The FMLA also includes pregnancy-related disability, as well as a qualified exigency relating to a close family member's military service.
And, just to point out, Pooja is referring to the California Family Rights Act, the CFRA. I say this CFRA. So it just depends on the attorney, but that's what we're referring to.
Yes, thank you, Anthony. Yes, so that is exactly what we're moving on to next, which is the California Family Rights Act. CFRA, CFRA, however you refer to it. This is the California Family Rights Act, and this one is more broad than the FMLA. It applies to private employers with 5 or more employees. And it has that same eligibility requirement for employees. So it's employees who have been employed for a total of at least 12 months prior to the commencement of the leave. Again, that does not have to be consecutive, but they would also have to have worked 1,250 hours in the previous 12-month period. The CFRA also provides the same amount of leave, which is 12 weeks in a 12-month period. And something that recently came out with the CFRA is if you have 2 parents of a new child working for the same employer, parents do not have to split up the 12 weeks of leave. Instead, each parent is entitled to up to 12 weeks of leave. This was something that prior parents that worked for the same employer were required to split that 12 weeks. Now they're entitled to 12 weeks each if it is for a new child. The CFRA's qualifying reasons are similar, but a little bit more expansive. So the similar reasons include the employee's own serious health condition, as well as bonding with a newborn, an adopted child, or a child placed in foster care, as well as the qualifying exigency relating to a close family member's military service. The CFRA is broader when it comes to a reason for caring for a family member. It has defined a family member to include a parent, a child, a grandparent, grandchild, sibling, spouse, registered domestic partner, parent-in-law, and it also has this other designated person. So the employee could identify their designated person and they would take their leave based off of that individual that they've designated as their designated person under CFRA. Now, bereavement leave is something that is under CFRA, and it does, again, apply to private employers with 5 or more employees. And the requirement for employment under bereavement leave is that they just have to have been employed for 30 days before taking the leave. So that hours of service doesn't apply here. You just need to look, have they been working for you for at least 30 days? And that would provide a qualifying reason of a death of a spouse, child, parent, sibling, grandparent, grandchild, domestic partner, or parent-in-law. and it provides 5 days of leave within the 3-month period after the death per death of a family member. So if an employee has multiple deaths in the family of multiple individuals under this list, they would get 5 months for each death. All of these leaves here that we're talking about are unpaid. The employer does not have to pay the employee. However, these leaves are job protected. A similar leave is the reproductive loss leave, which also applies to private employers with 5 or more employees. And again, this one just requires the employee to have been working for the employer for at least 30 days prior to taking the leave. The reproductive loss event not only covers the employee's own reproductive loss event, but if it was a loss of another person, such as the spouse or a partner, essentially, if that child was born or adopted, that employee would be the parent. So if it's the spouse who has a miscarriage, that employee would still be qualified for reproductive loss. If it was a surrogate that had a reproductive loss, it would still apply for the reproductive loss leave. And that includes miscarriage, stillbirth, failed adoption, as well as unsuccessful assisted reproduction, which is including failed embryo transfers. This leave also provides for 5 days within a 3-month period after the loss per loss. However, it is capped at up to 20 days per 1-year period. So if an employee essentially has more than 4 losses in a year, they would have used their 20 days and would not be entitled to additional reproductive loss leave. However, you want to be sure you're looking to see if there's any other leaves that they may qualify for. Are there reasonable accommodations? They may qualify for something under the pregnancy disability leave, which we'll discuss next. And the pregnancy disability leave, or the PDL, this is a California specific protected leave, and it again covers employers that have 5 or more employees. And this one doesn't have an eligibility. It's for all employees who work for a covered employer. They're eligible for the pregnancy disability leave upon hire. This leave provides for up to 4 months or up to 17 1/3 weeks per pregnancy. This does not have to be taken all at once. We're going to go into a little bit more detail on intermittent leave later on. So this is something to keep in mind, and it is very common with pregnancy disability leave to not take the 4 months right at the same time. The qualifying reason for the pregnancy disability leave includes when an employee is disabled by pregnancy, childbirth, or related medical condition. So this includes prenatal, postnatal care, severe morning sickness, if a doctor orders the employee to bed rest, as well as childbirth, recovery from childbirth, and loss or end of pregnancy, or any other related medical condition. And that last bit is important because, as we discussed earlier with the reproductive loss, they're entitled to 5 days per loss. However, there may be additional leave that the employee may be entitled to under the pregnancy disability leave for a reproductive loss.